counsel. You're live in the courtroom and the hearing is about to begin. Please remember to state your name for the record when you speak, and every time you speak. Please stay muted if you're not speaking to the judge, so the judge can concentrate on the parties that are presenting at the time. Thank you.
Good afternoon. This is Judge Stickles. We're on the record in Lannett Company, Inc., case number 23-10559. I've reviewed the debtor's motion to shorten with respect to the debtor's motion to disband the committee and the objections filed by the United States trustee and the creditors committee. The motion to shorten is denied. The purpose of this status conference is to address scheduling on the motion to disband the committee, and I'm curious if the parties have had an opportunity to confer regarding the scheduling of the motion.
Good afternoon, Your Honor. Howard Cohen, Fox Rothschild, counsel for the debtors. I believe my co-counsel from Kirkland & Ellis is on the Zoom call, so I'll let them address the court. Thank you.
Okay, thank you, Mr. Cohen.
Thank you, Your Honor. Nicole Greenblatt on behalf of the debtors from Kirkland & Ellis.
Good afternoon.
Your Honor, we did not know the motion to shorten would be denied, obviously, until we got on the status conference. We have conferred with proposed counsel for the proposed committee. They asked us to simply withdraw the motion. We have not had any further conversations around scheduling. I'm happy to kind of lay out our case and give you some suggested ideas we've had on the side, but no, we have not conferred as a group with respect to it.
Go ahead.
Thank you, Your Honor. Look, I think we're obviously very concerned about timing. As I said at the first day hearing, these cases were a long time coming, and the prepackaged plan was pretty thoughtfully developed to maximize value. We, as the debtors, are very cognizant of our fiduciary duties, including to unsecured creditors and all stakeholders, and we're not here to disenfranchise anyone. That is not what this motion to disband is about, nor is it what the motion to shorten was about. To the contrary, we believe we have an absolute duty to keep these cases on track and on the full and fair timeline that Your Honor established on May 4th, precisely so that we can deliver the value reflected in the plan, which is, again, a full, unimpaired recovery gifted to unsecured creditors by senior stakeholders who are taking a massive discount. I think it's worth level setting, Your Honor, that we're equitizing approximately $570 million of senior secured debt in exchange for equity with a desktop value of approximately $283 million. And it shouldn't be lost on anyone that that gift in the plan is premised on certain timeline and budget for these cases, which again are being financed exclusively by the use of the debtor's existing cash. This is not a case where we have a dip with unfunded resources, unlimited resources. So from our perspective, Your Honor, it's very hard to see a justification for the appointment of a creditors committee in these cases when, again, if there was any mystery value to be unlocked, it would first have to satisfy hundreds of millions of dollars of shortfall owed to senior secured creditors. And so we felt compelled to move quickly because we don't have the luxury to sit idly by while a committee runs up costs and potentially threatens our timeline and budget and the successful outcome of these cases for what we see as no conceivable benefit to unsecured creditors. The fact, Your Honor, is the only thing the committee can do and has stated its intention of doing is to slow these cases down, which we fear jeopardizes recoveries to unsecured creditors by depleting the value that's available to junior stakeholders and really for the benefit of one party in interest, which are the convertible note holders. And Your Honor, I think courts have long recognized that funded debt holders like the convertible note holders are not typical unsecured creditors requiring a committee. These are sophisticated parties with the means and ability to represent their own interests. And in fact, it's quite common for indentured trustees and their counsel to play a role in prepackaged cases outside of a formal committee role. They can and have successfully negotiated settlements, and the Bankruptcy Code expressly provides a route for them to seek a substantial contribution claim to the extent that happens. So we see no harm to that one party of disbanding the committee, and effectively what we have is a committee operating for the benefit of only one party. Indeed, Your Honor, this is not a typical case where a committee comes in to improve recoveries to unsecured creditors. They simply cannot do better than the unimpaired gift they're getting, which is wrapped in a bow in a prepackaged plan where we gave every party in interest a full 35 days notice of confirmation as required by the code and this district's local rules. We have the requisite votes locked in and we stand ready for confirmation. The pleadings suggest that this is not a true prepackaged case because $85 million of convertible debt is being wiped out on a non-consensual basis. But the fact that it's a cram-down plan, Your Honor, does not make it not a prepack, does not make it non-confirmable, and does not justify the need for an unsecured creditors committee with costs to be borne by these estates.
Okay, well, not to interrupt you, but we'll address that issues when we get to the motion to disband. I'm curious what the parties propose in terms of the schedule, because clearly I was not going to have a hearing on a motion to disband a committee in 24 hours. So.
Well, so I think more to the point on timing, Your Honor, from our perspective, all the legal issues raised in the objection to the motion to shorten and the motion to disband that we've seen so far relate to confirmation issues and to the cram down plan. These are issues of valuation, unfair discrimination, well-settled issues in the Third Circuit that can and should be in connection with confirmation and can easily be built into the schedule for the next 2 weeks. And Your Honor, we've seen the pleading suggesting we're seeking extraordinary relief, but you have to understand from our perspective, it was extraordinary and unexpected to have a committee appointed, and we found ourselves with a conundrum where if we put this motion on regular notice, it would be heard literally the same week as our confirmation hearing. And so we asked you to shorten notice and disband the committee or agree to hold it in abeyance until after confirmation so that we could get through that. On our end, we've been talking about in the alternative, if Your Honor is not inclined to proceed on short notice, we think it might be appropriate and perhaps help impose some discipline on costs if we adjourn the motion to be heard simultaneously with confirmation. And so counsel on all sides, including counsel for the indentured trustee and counsel for the committee, be mindful of any, basically take some risk on whatever fees are imposed in driving litigation around this case, given the facts and circumstances.
May I hear from proposed counsel for the committee?
Good afternoon, Your Honor. My name is Todd Myers. I apologize that it says my partner's name, Gianfranco Finizio, on the Zoom. I did not get the link for some reason, so he shot it over to me. So, but speaking is Todd Myers. Your Honor, I'm with Kilpatrick Townsend, together with the Womble firm. We are proposed co-counsel to the Official Committee of Unsecured Creditors. We were hired 2 days ago, which I think was the day after the committee, or the first business day after the committee was formed. So obviously breathing by a fire hose. Your Honor, I have a lot to say about in response to Ms. Greenblatt's arguments on the merits of the motion to disband, but I'll take Your Honor's lead that we're not going to argue that right now, nor should we. In respect of the timing for hearing this motion, it is the debtor, the movement's burden to show that the actions of the U.S. trustee were arbitrary and capricious. I don't know what evidence that they intend to put on. They alleged in their papers that one of the committee members was appointed in respect of a $1,500 trade debt. We believe that is preposterous, that they were obviously appointed in their capacity as the indenture trustee for $80 million in notes. But if they intend to put on or make that argument, we would like to know what evidence they have of that. So I'm a little uncertain of whether discovery is going to be needed on this. Perhaps with some stipulations we wouldn't need it, hopefully. Next week is a holiday week. I'd be happy to have this heard the week after, and we can brief it accordingly.
Bear with me a second. So are you proposing the week of June 5? Or
Yes, Your Honor, I think that's fine. But I fully expect that the committee is going to take the actions that a committee takes, particularly in one where at least the purported timeline for this case is that the confirmation hearings in 2.5 weeks. We're going to be doing what committees do until such time as we're disbanded.
Well,
so,
June 8th is the confirmation hearing. So are you proposing that this be heard on the same day as the confirmation hearing?
Assuming the confirmation hearing goes forward on June 8th, I think, Your Honor, one of the first things this committee is going to do is ask Your Honor to reconsider the timeline. The mere fact that a debtor decides to solicit their plan the day before bankruptcy rather than, a week or two into a bankruptcy doesn't change the fact that when you have a class that's not only being impaired but is getting nothing, that's not a true pre-pack, and that group of creditors and all creditors are entitled to the process of determining whether they truly are out of the money. Just because Ms. Greenblatt says that doesn't mean there's any evidence of that. And so we believe that the creditors are entitled to full just, information and process regarding valuation, efforts to sell prior to the petition date, assets at subs, assets at the holdco, intercompany claims, and determine whether or not the creditors are being treated appropriately under this plan. So I think we're okay with it. That we are okay with the hearing on the motion to disband that week. Frankly, we're okay with the hearing on the motion to disband at the confirmation hearing, but we're not conceding that the confirmation hearing should be on the date that it's currently scheduled.
Your Honor, may I be heard?
Yes.
Thank you. Benjamin Beller from Sullivan and Cromwell on behalf of the consenting stakeholders. I understand Your Honor is not hearing arguments on the motion, but I want to point out the way that we're talking about issues here, I think makes very clear the concerns that the debtors and the consenting stakeholders have about what's happening in this case, which is that you're hearing about how delay of the timeline is in the interest of the committee and its constituents, but it's not in the interest of the committee and its constituents. It's in the interest of the convertible notes holders. And while they are a member of the purported committee, they are not unsecured creditors. The unsecured creditors are being, the holders of general unsecured claims as defined in the plan are unimpaired. The only interest that they have is in having that plan approved as quickly as possible. So there is a serious concern from the debtor side and from the consenting stakeholder side that there is a fundamental and irreconcilable conflict of interest between the members of the committee and for the proposed counsel of the committee. And to the extent that we're talking about discovery going forward, the debtors and the consenting stakeholders will be evaluating discovery into the committee members, the formation of the committee, and how the interests of holders of general unsecured claims are in fact being represented by this purported committee. And again, I think it is clear that this deal that treats unsecured creditors other than the converts as unimpaired is premised on a specific timeline and on a specific budget. We had many months of negotiations with the debtors. So we were evaluating whether in fact a plan that unimpairs holders of unsecured creditors was the best thing for the business going forward. And we evaluated what a plan that does not unimpair unsecured creditors looks like. At the end of the day, our clients, along with the debtors, determined that a plan process that unimpairs holders of unsecured creditors, despite the cost, despite the substantial haircut that the secured creditors are taking, was worthwhile, was the best thing for the business. If the debtors are now required to bear the costs of a plan that does not unimpair those creditors, then we will have to evaluate whether we in fact should be just doing a plan that doesn't unimpair those creditors. And that again is the fundamental conflict of interest that is at issue here. And so we will get into it all whenever Your Honor decides to hear the motion. But I would be remiss to not point out that what we're hearing in this conference is exactly what we are concerned about.
Your Honor, may it please the court, Donald Detweiler from Womble Bond Dickinson on behalf of the official committee of unsecured creditors. The issue and the sole issue really for the purposes of this conference call is to schedule the time for the motion to disband should the moving parties wish to move forward with it. I think what you've heard from the committee, despite all the other discussions, is we're prepared to have this within 2 weeks. And if it falls on the confirmation date, it will fall on the confirmation date. What you also heard from Mr. Myers is the committee is prepared to file a motion asking Your Honor to reconsider her order with regard to the date of scheduling. What I personally would suggest, and I think Mr. Myers would agree, is that we should go ahead and file that motion with the court, requesting Your Honor to reconsider the scheduling of the confirmation hearing. In the meantime, it may be very well that you can keep the motion to disband, again, should moving parties wish to go forward with it, on the date for the confirmation hearing. And then simultaneously, Your Honor can consider, hopefully before the confirmation hearing date, whether or not it's appropriate to extend the deadline. But in the meantime, I can assure Mr. Beller and debtors counsel that the members of the committee take fully all responsibility as fiduciaries of the estate. They understand their responsibility, and they're moving forward as fiduciaries of the estate. So for scheduling, why not put this on at the date for the confirmation hearing, hear the committee's motion to reconsider the timeline for the confirmation hearing. That may move the confirmation hearing, but at least we have the motion to disband set for the court. The parties can brief the rather important issues that are raised by the motion, and we move forward from there. Thank you, Your Honor.
Thank you. Does anyone else wish to be heard? Mr. Cudio?
Yes, good afternoon, Your Honor. Joseph Cudio for the United States Trustee. The UST does not oppose June 8th as a date to hear the motion to disband the committee. Our concern here is the weighty nature of what's going to be decided at that hearing. And in addition to time to brief it, I'm sure that anything we'll file in this case will require layers of review several steps above me. So we do not oppose June 8th. As far as our side, we don't anticipate the need for any discovery. But we do reserve our rights as to response to any requested discovery from the UST. And that's all, Your Honor, unless you have other questions.
I don't. Does anyone else wish to be heard? Okay, I'm going to schedule the motion to disband for June 8th. At the same time, we previously had the disclosure and confirmation hearing scheduled, which as of this time is still at the same time. But I would ask the parties, because it is an expedited proceeding, to confer in advance, confer who your witnesses are, if there is anything to be produced, that you agree on a schedule, because I don't want to be on the eve of the hearing on the motion to disband and be presented with issues regarding, disclosure and delay. So I would ask that the parties submit a scheduling order to the court. Is there anything further for today? Okay, thank you all for jumping on a status conference so quickly. We stand adjourned.
Thank you, Judge Stickles.
Thank you, Your Honor.
Good afternoon. Thank you.